Speaker, I rise under Standing Order 53, subsection 3, as read together with the Standing Order 139, subsection 1.
In a motion moved by the Leader of Majority, Aden Duale, the National Assembly has brought to pressure over the controversial Parliament Powers and Privileges Bill 2014 and will now reconsider the controversial Article 34.
Honorable Speaker, what are my justifications? 1. This request is informed by the need to allow for further reflection on the contents of the bill and the provision carried therein. It is undisputable that several provisions contained in the bill are offensive to the general rights and freedoms as exposed in the Constitution.
I'm very happy by the renewed sense of responsibility by the majority leader. Speaker, I wish that in future we will be looking at these bills in this manner.
But I'd want to request, Mr. Speaker, that in future I'd want to encourage the Leader of Majority with whom we were in the last Parliament, that whenever we have bills of this nature, it is easier to have a kamkunji, so that by the time we are coming to the House, we have already dealt with the thorny issues.
Article 34 of the controversial bill that placed punitive fines for anyone publishing supposed scandalous information from the House had raised storm amongst media stakeholders and across the political divide.
Right now we have many issues that are noisy. The interest rates are at 25%. There are so many things which we can do for our nation that should occupy the media space to lead this country into the next generation. So, Mr. Speaker, I plead with you to put this, putting this question for a later date.
Mr. Speaker, indeed, Mr. Speaker, if you look at the Constitution at Article 34, it is very clear, Mr. Speaker, that freedom and independence of electronic, print, and all other types of media is guaranteed by this Constitution. It goes to say that the state shall not exercise control over or interfere with any person engaged in broadcasting, the production or circulation of any publication or dissemination of information by any medium.
It is not constitutional. We do not have to go to court to be told. Secondly, Mr. Speaker, this bill will not only end with this House, it is also heading to another House. I am sure you know what will happen. Mr. Speaker, do you want to look bad? We are told by another House, which is lower than ours, Mr. Speaker, that we did not know what we were doing.
The bill was said to be put to question before being moved to the Senate for its final deliberation.
Acting not understanding order number 1 as requested by the Honorable Chepkonga, but acting understanding order number 139, I would defer the putting of question in third reading of this bill and refer this matter to the House Business Committee to make a decision after reflecting on all the issues, make a decision as to when the question in third reading may be put. I thank you, Honourable Member.
The Media Council of Kenya termed the article retrogressive and an affront to accountability.
The time has come for this country to do away with the criminal defamation, which public officials have resorted to as a sword to persecute, to silence and ban accountability and demand for citizens. There are enough existing laws, such as the Media Act 2013, that can be used by the authorities to professionally deal with the journalists who go contrary to the code of conduct for the practice of journalism.
From the moment the bill was first drafted, the media has engaged the National Assembly in consultation sessions that include, most memorably, a meeting with the Speaker and the top leadership of the National Assembly. These consultations seemingly proved futile.
KOTU Secretary General Francis Atwoli had petitioned the president seeking his intervention. In the petition, Atwoli has called on the president not to taint his hands by assenting to a law that stands to remind Kenyans of painful past and should instead refer the bill back to Parliament for amendments to be in conformity with the national constitution. Amani National Congress leader Musalia Mudavadi too had no kind words for the bill. In a statement, and I quote, Mudavadi said the Powers and Privileges Bill passed by the National Assembly is draconian and a bad experiment in legal impunity. It paints the National Assembly as an unlawful example of an institution in governance. He further stated the bill makes Parliament a monarchy, not open to public scrutiny, something that cannot be allowed in Republican Constitution. End of quote. Achola Simon for Channel 1 Business Insight.